So going to have emails. Okay. Salama. I was spoken on phone. I think on phone. Yes, but we needed you. Yes. We have to be here. Yes, sure. Yes, we have not told you guys joining. We have not told you guys joining. Collins. Yes, he's handling another matter. Okay, that's right.
Good morning, Your Lordship.
Good morning.
My name is Miriam Maya. I hold brief for Ms. Mwala's release for the second interested party.
Thank you.
If it may please Your Lordship, my name is Kip.
For the third interested party. Mr. Where this matter is coming up? Yes.
Jamaa Desiree for the National Gender and Equality Commission, together with Nancy Mwangi. We have an
May I have your name again, please?
Desiree Jamaa.
Yes.
Ms. Nancy Mwangi for the National Gender and Equality Commission, 4 dissidents.
And the respondents' application seeking to discharge the interim orders were coming up today. We are ready to proceed, speaking for the petitioners, but I'm also aware that the National Gender and Equality Commission filed their application, which, according to the directions served upon us, was coming up for directions today. For good order, we were proposing that you give directions on that application, one or the other, then we proceed with the two substantive applications coming up today.
I would be requesting the court that we dispense off with the matter of the date, which is highlighted, and then we can take directions on that application.
Agree with what has been said before me by my lad senior, Mr. Ongoya, and I equally am of the view that we should take directions on the application by the proposed interested party. Thereafter, we can converse with the primary business of the day.
Mr. Wyatt? Sorry, Miss. Miss, for the National Gender and Equality Commission, did you serve?
Yes.
You served.
Is the internal service.
Service. Would you have wished to participate in the...
My Lord, we are not wishing to participate in this application. We are seeking to participate in the main petition.
in these applications? There are two applications. business of time allocation? Mr. Ongoya, what is your estimate?
We were estimating that if you gave both sides 1 hour, and it's in that context that when parties leave this court, either those who are following online or those who are present here, they understand what each party is saying, and that a ruling comes out one or the other. They understand why the ruling came out the way it came out. It's in that context that I think 1 hour for each side would be adequate, just in this case. Speaking from our own time management, we may endeavor to use less than that from our own time management, but in terms of reservation, so that you don't keep pushing the court for additional time, we think that reservation is reasonable and proportionate.
That has been requested by each party. We would break off at lunch hour and still not have started the interested parties. So it's not possible for it to be 1 hour. Could you not make do with 30 minutes?
That's okay. We'll do 30 minutes.
Me, because I am a stickler for that time.
Yes.
Let me find my time. "30 minutes. The respondent, 30 minutes. Each interested party will have 20 minutes on the understanding that you will limit yourselves if the issues have already been covered." Mr. Ongoya, you may begin.
Thank you so much. For good order, the Speaker of the Senate, then my learned colleague, Mr. Mutuma, will submit on the rest of the matters arising out of these two applications. Again, for good order, we filed 2024 together with a bundle of authorities.
Yes.
We also filed the petitioner's supplementary affidavit sworn on 4th September 2024.
Yes.
And these are in addition to the application and the supporting affidavit of 21st August 2024. We adopt and reiterate all the contents of the three sets of documents.
Yes.
Allow me, therefore, to go to the issue whether the respondent is properly joined to these proceedings. We submit that the respondent is properly
for discharging the conservatory orders is premised on that one ground, that we have sued the wrong party. My learned senior, having dispensed with that issue, that notice of motion, my lord, lacks merit and ought to be dispensed with.
Premised on that sole ground, lacks merit, and should be
Dismissed.
dismissed. Yes.
My lord, the principles that guides a court that sits to consider an application for conservatory orders, such as the one before you, have been established by our courts.
Yes.
All we need to demonstrate on behalf of the applicant is that she has a prima facie case with a likelihood of success.
Yes.
My lord, secondly, the applicant is supposed to demonstrate that in the absence of conservatory orders, she is likely to suffer prejudice irreparably.
Yes.
Thirdly, my lord, is that either the grant or denial of the conservatory orders
I briefly address the question of what, where, when, why, and who with regard to the impeachment procedure. I will not focus much on what, where, when, Your Lordship, but I will examine who impeaches, Your Lordship.
Yes.
Your Lordship, with regard to the subject of the impeachment, it is easy to state that is the governor, Your Lordship.
Yes.
But with regard to who impeaches, Your Lordship, it is the County Assembly and the Senate, Your Lordship.
Yes.
Your Lordship, under Article 177(1), a County Assembly is elected into office by the constituents of that county, Your Lordship. That is the people of Meru County.
Let me begin by asserting that it is sound principle in constitutional interpretation that a constitution must be read as a whole. Let me just begin by asserting that as a principle and make the following then statements of rejoinder. It has been said that what is at issue here is the sovereign power of the people of Meru. Let me summarize that as the issue. To that, we respond as follows, that it is true that all sovereign power first belongs to the people of Kenya, with a rider that it shall be exercised only in accordance with this constitution. Only in accordance with this constitution. The petitioner is telling you that this rider has been violated. That's what the petitioner is telling you. This rider has been violated. That this power has been exercised in violation of this constitution.
Yes.
The second issue that has arisen is that the petitioner has no, may I call it, private or proprietary interest in the office of governor. A submission was made to that effect.
Yes.
Again, let me read Article 38, Clause 3, Paragraph C of the Constitution. Article 38, Paragraph 3, Article 38, Clause 3, Paragraph C. It says, every adult citizen has the right, without unreasonable restrictions, to be a candidate for public office or office of a political party of which is a member, and if elected, to hold office. The governor is saying, I have a constitutional entitlement to hold office unless I am constitutionally removed. And he's saying the removal here is
Public interest is in favor of granting conservatory orders, and there would be absolutely no prejudice on the part of the respondents, or indeed any other party, if conservatory orders are maintained. On the contrary, the damage would be irreparable, both to the petitioner and the public, should the conservatory orders herein be discharged. On that basis, my Lord, we wish to rest our case and wish you a good afternoon.
Thank you. Both the application for the interpretatory orders as well as the counter application by the respondent. Ordinarily, I would be proceeding to issue yourselves with a ruling date on both applications. I'm not able to do that today. I think, Councillor Ongoya, you noted you had not paginated.
yes. May I remedy that right away? I've paginated, so I can withdraw that and give you a paginated version, so that I just remedy right away.
You will you'll do that administratively with our Mr. Guyo.
I appreciate.
The other issue is on your submissions. Mr. Guyo will engage with yourselves. He'll give you my court email address so that I can have your submissions in Word, not the annexures,
Yes,
just
yes.
the text of it. You can have a mention, because I don't want to take us ruling.
Any objection? It will be virtually. October, any objection?
There is no objection, sir.
to kindly have you, could we as well reserve a ruling date even as we mentioned on the Tuesday?
Now my fingers have been burnt when I've done that, where when I retire I find there's been no compliance, and then I have to issue a date calling for my my previous date. 15th is not too far away, so make sure everyone has filed everything. I also encourage you, because I've not gone through every page of every volume. Mr. Guyo, help me with volume 6. Of annexures, it runs to page 3742. I encourage all parties to ensure that what you've uploaded into CTS is legible. I can clearly read it, so just go in and confirm. And also you can help me, you can assist me greatly by giving me hard copies. So we'll be coming on Tuesday to confirm that, so that I have hard copies that I then use for a ruling. Now, Mr. Kirimi, I hear you. Let me assure you that between myself and my able Mr. Guyo, we already have a date, and that is the date we will be informing you on Tuesday next week. So, Council, thank you very much for your patience and your very, very good submissions. Let's meet on Tuesday.
Orders extended.